Supreme Court has to be deeply conscious of an important role that it has been assigned under our constitution, which is to be a counter-majoritarian institution, right? Not an anti-majoritarian, but a counter-majoritarian. There are clear domains within which the executive and the judiciary operate in the area of remissions. But this much is certain that order granting remission is certainly amenable to judicial review. And so that is what was the issue here, whether it's amenable to judicial review, whether the executive had all the facts before it took that decision, and how did it go about. See, there are two things. One is the decision-making process, and the other the decision itself. And so the scope of interference by the judiciary in acts of the executive in granting remissions and pardons is fairly limited, but definite. Yeah, these are matters for concern, because you must have some predictability of how long it will take to hear and dispose of a bail application. But there could be other aspects to the case which you may not be privy to, and only people involved in handling the case will be aware of. And there could be a lot of strategizing around court hearings. So all said and done, I think there should be definite time limits within which bail applications should be disposed of at each level of the judiciary, whether it's the trial court, the High Court, or the Supreme Court. I think it's a no-brainer. It's an unacceptable proposition that without notice and without a hearing, you will just simply demolish a person's house. And there must be a provision in law that enables you to do that. Just because you participated in a protest against the government does not mean your house gets demolished. You know, there is a whole process, legal procedure. Ultimately, much of justice is following the procedure. And if there's a violation of that very basic procedure, then there's clear violation of, a clear miscarriage of justice. So I don't think our constitution and the laws and our system of rule of law can tolerate this kind of bulldozer justice. It's simply unacceptable in our scheme of things. See, legislating by the court is something that in India we see often. And one of the early instances was in the case of sexual harassment at the workplace. The Supreme Court came up with a set of guidelines and said these guidelines will hold till such time Parliament passes a law. So it is a kind of legislation by the court, which very rarely happens in judiciaries outside of India. But because there has been no law on the subject and the need is urgent to address the problem, the court comes up with this approach. Likewise, in this election commission appointments, the court, if you see the judgment, says that this will be the arrangement till such time Parliament makes a law. And now Parliament has made that law. The law will have to be tested. So there is always an issue of jurisdictions, that is Parliament's domain and the judiciary's domain, and whether one can, take on the other without, violating the rule of law framework. If you look at the number of cases being instituted in our courts year after year, it's an increasing trend. So actually falsifies the claim that people are losing faith in the courts. They wouldn't come back to the courts for more cases. There's a whole set of people who are there in the system not out of choice but out of compulsion. People who have been falsely accused of committing offences which they never did. So they don't have a choice in the system. So the right way to see it is that people still have hope in the system. And since they still have hope in the system, it's up to us to redeem that hope, despite all our limitations and other compulsions that we may have. And that task can't be, compromised. And we must do it with all sincerity and to the best of our abilities. Yeah, one is that the Supreme Court has to be deeply conscious of an important role that it has been assigned under our constitution, which is to be a counter-majoritarian institution, right? Not an anti-majoritarian, but a counter-majoritarian. The court is here to uphold rule of law and justice, and therefore it can't be swayed by what a majoritarian opinion might be. So even though a court may be unpopular, it is expected to perform this role of being a counter-majoritarian institution and to stand up where it perceives injustice. So that, I think, the Supreme Court would have to remind itself time and again. Whenever it has done that, it has come in for a great amount of praise. Whenever it has failed, it has come in for criticism. So it's been an uneven record, as I would look at it. And there is still hope that the Supreme Court might regain its principal role as a counter-majoritarian institution.